Adjournment request, if any, from item number 1 to 7. From item number 8 to 17.
In respect of item number 17, I have taken 17 after vacation, after item 17.
So concept,
Applicant about-
we are insisting, please send us adjournment slip. If you don't want to argue, send an adjournment slip in advance. Take care. Adjourn.
Month of August.
Yes, adjourn. After summary. Obviously.
Your Lordship, I would like to mention IA number 1932/24, which has filed on the last date. We would like to list on 28th of this month, Your Lordship.
Urgency.
Yeah, we have that WPC has been order has been passed.
What's the urgency in that?
Yeah.
Only it is likely to be listed. It has already been filed. It is likely to be listed in this week only.
Yeah.
However, for convenience sake, we'd like to list on 28 because all the councils are engaged from Manipur, new councils.
28th would be very difficult as the last working day.
In that case, 27th. Even otherwise, it will be listed this week, Your Honor.
7th.
27.
Yes, Your Honor.
Adjournment request from item number 18 to 30.
May I please, with respect to item number 18, this is an appeal filed by the revenue. I was supposed to produce one judgment of Calcutta High Court. But in spite of that, I could not obtain the copy of that judgment. It is not available in any of the website.
Get a certified copy from court.
We have requested the Calcutta office to
Again, August.
much.
Yes.
Maybe Your Lordship, beg to mention item number 25, Your Lordship. I'm appearing on behalf of Mr. Y. Ali, Your Lordship. In this case, he's leading this council, Your Lordship. His relatives has expired today, Your Lordship. That is why he has gone to. Obligation.
From item number 32 to 39.
May I please, Your Lordship? Lordship, I beg to mention item number 32. Lordship, we have, the reply is ready, but it is to be vetted by the petitioner.
Yeah.
Much obliged.
May it please your Lordship, my lord. My lord, in item number 27, my lord, we have filed one additional affidavit that may be called for, my lord. Obliged.
May I please, Your Lordship. Lordship, I beg to mention item number 38. This item is listed for hearing. For the senior, in the system of senior counsel, that is, as Banerjee had died. So he could not prepare the case, so we need some time, 2 weeks times. Item number 30.
May I, regarding item number 37, my lord, my brother is there for petition, my lord.
My lord, we have a joint prayer, my lord, for item number 30. Kindly pass over the matter for the day, my lord.
Which one?
Item 37, my lord.
37, my lord.
Passport for the day. Passport for the day.
Adjournment, my lord.
Adjournment. For the adjournment for today, my lord.
Some difficulty, or let the matter be come up after vacation.
Passport for the day.
Much obliged. I'm deeply obliged.
37.
37. my lord.
37.
Passport for the.
May please your lordship, listed for hearing. Why it is there is urgency in spite of the honorable court stay
Yeah.
lordship
Yes, yes.
listed for hearing. And how urgency is there, but there in spite of honorable stay order, they already as a public service have already conducted the interview. We are going to be victim. Your lord,
Hearing matter.
hearing matter.
We are taking motion matters in this week.
No,
only.
No, your lordship, I mentioned this. I am filing. I am submitting the mention memo
After summer vacation, it can be listed.
after summer vacation.
Yes.
Must-
May it please, Your Lordship. Lordship, with the consent of the other side, I beg to mention item 39 of today's debate. So, Lordship, my senior has some difficulties.
My lord, the interim may be continued, status quo order is there.
Interim order, if any, to continue till next day.
Lordship, I'm praying for listing of a writ appeal, Lordship, this Thursday, Your Lordship, fresh writ appeal, Your Lordship. Lordship,
What's the urgency?
Lordship is a tender matter, Your Lordship, 26.
Will come after summer.
After vacation.
Lordship, our tender has been terminated, Your Lordship, it's a writ appeal.
After summer.
So the fresh matter, Your Lordship, freshly filed, Your Lordship.
Yes. Fresh matter, then it will be listed, where is the question of giving permission? If the fresh matter is already there, we have already inspected the registry, is there any urgency, that will be listed, no permission from this.
Lordship.
Daily list for orders, item 1.
The quantum case, Lordship, the matter that the state had preferred a review, Lordship, writ appeal review petition has been allowed, Your Lordship, hence the
Yes, sir.
quantum petition will be given.
In view of the order passed by this, full bench of this court in review petition number 149/2000, 149/2019 and writ petition number 5002/2012. This contempt petition has become infectious, dismissed as infectious, notices discharged.
Item number 2.
My pleasure, Lordship. In this case, my lord, service report upon the respondent is awaited. We have taken steps, second time, my lord. Office note dated 6/6/2024.
Fresh step 17/5/2024 notice have not been. Await return of notice of respondent number 1 for 4 more weeks.
Obliged.
Item 3 and 4.
May I please, Your Lordship?
Yes.
Lordship, we have filed a representation before the Secretary, Lordship, and filed an affidavit annexing that representation also.
Yes.
But regarding this representation, I have to obtain instruction, madam,
What,
because on the last order, there's a direction to approach the secretary,
yes,
and he's submitting that he has approached the secretary, madam. So I'll, the secretary is not the party, so I'll obtain instruction from the secretary, madam.
Nikhil, and consequence of the petitioner has submitted that pursuant to the direction given by this court on 3/5/2024. The petitioner has already filed a representation before the Secretary Department of School Education. Which date?
Lordship, on 9/5/2024.
9/5/2024. Stop. Then the counsel appearing for the respondent place some time to apprise the court about the fate of the representation filed on behalf of the petitioner. List on 25th of July.
Obliged.
Item 4 representation date is defined, Lordship. Item 4 on 9/5. Item 4, Lordship, liberty may be, item 5, Lordship, liberty may be granted to file.
Same, this is the same.
5 is no representation file, Lordship.
As per the office note, that they taking public. What order you want?
5.
Item 5.
No.
Item 5.
Similar, Lordship, liberty may be granted to file representation before the secretary, Lordship. in this.
Is informed by the council for the respondents that the
Notice of business.
director Secretary Education Assam has already recommended the matter for the for regularizing the services of the petitioner as per the terms of the order passed by this court. And the matter is pending consideration with the Secretary Education Department. So, consent for the full stop. Petitioner is at liberty to approach the Secretary Department School Education to act on the recommendation made by the Director Secondary Education Assam within a period of 10 days. Let's start before we.
Item number 6.
I am for a exponent, madam. So on the last of the petitioner's advocate was not appeared, madam. The second wife claimed the pension and benefit right after demise of the first wife. Most of the extra copy was not served, madam.
Non-present of for the petitioner with this matter for admission for summer vacation.
Item 7.
May I please, Your Lordship? My lord, as per the Lodgema court order dated 19/6, I need to take fresh step with the respondent number 6 and 7. So I may be allowed some time to defend it.
2 weeks time is granted to the council for the petitioner to take steps for service of notice upon the respondent number 6 and 7 as per the order passed by the Lodgema court dated 19/6/2024.
Highly obliged, Your Lordship.
Item 8.
May please your lordship, my lord, here I appear for the contempt, my lord. Here lordship's direction was twofold, my lord, to allow the petitioner to join in her service and to release her salary, my lord. Here, my lord, petitioner has already joined in her service from he is serving, my lord. And secondly, my lord, from April 2004, her salary has been paying, my lord. Some area is there, my lord. It will be processes going on and very soon it will be released, my lord.
I filed a reply, no, against the.
Already filed the reply. What about the areas of the salary?
That I have not, I've been paid, I have not been paid, madam.
Yeah,
I've been paid, my salary has been being paid since April 24, my lord.
yeah.
Yes, but my salary is pending since April 23.
It is under process, my lord. Very soon it will be released, madam. That is my instruction.
And then concept of the contender estimated that pursuant to the direction given by this court, the petitioner has already been allowed to join at the new place of posting. And she is being regularly paid salary from April 2024.
24.
As per the submitted that so far as regarding the areas of the salary, the areas of the salary of the petitioner is concerned. The process is undergoing and the same will be paid within a period of
4 weeks, my lord.
4 weeks, list after 4 weeks.
Obliged.
Item 9.
May I please, Lordship? In this case also, my lord, service report upon the respond number 1 is awaited. May I pray, my lord, list the matter after vacation, my lord. In the meantime, if my lord remain answered, we may take fresh steps after vacation, my lord.
With return of notice of respondent number 1 for 4 more weeks.
Obliged.
In order to need to continue till next week.
Obliged.
Item 10.
Lordship. So here also I'm appearing on behalf of restaurant number 5 and 6, Lordship. Today I have filed power, Lordship. I may be allowed for it time.
Respondent number 2, 3,
This is that respondent, Lordship.
2, 3 and 7.
I am for 5 and 6.
Yes. 2, 3 and 7, Mr. 2 I'll appear, 2, 3 I'll appear. 7 I'll appear.
Lordship, up to 6 is there.
No, 4 is there.
I'll appear for 2 and 3, my lord. 2 and 3.
My lord, director and inspector.
7.
7 to 9.
My lord, our copy does not have a 7.
Lordship, is looking at page number 2.
The 5 and 6. You are appearing for the 5 and 6?
Yes, Lordship.
Hafizur Rahman, na?
Yes, ma'am. Hafizur Rahman. Read it.
And you are appearing for 1, 2 and 3. 2 and 3.
And
What about
1, 2 and 3, ma'am. 1, 2 and 3.
Mr. Majumdar put an appearance on behalf of the respondent number 1, 2, 3. Ms. So-and-so is appearing on behalf of the respondent number 2. So-and-so is appearing on behalf of the respondent number 5 and 6. Service is therefore complete. This matter, IA is for?
Lordship,
There is no IA.
There is no IA, Lordship.
There is no IA.
No.
Is this matter for hearing after summer vacation? For admission, after summer vacation.
Obliged.
Item 11.
Yeah, last. Lordship, the last position, Lordship, I have taken step, Lordship, against the respond number 2, 3, 6 and 7, Lordship.
You have already taken steps.
Yes, Lord.
The notices are still awaited. Await return of notices of respondent number 2, 3, 6 and 7 for 4 more weeks.
Lordship, whatever, Lordship. So my area money, if possible, Lordship, directed to the disbursed amount, Lordship. Area money, Lordship.
Let them come. We have
He has
already
already
issued-
appealed against the impin order.
Yeah,
He has already appealed, my. The impin order has been,
If you,
let them come, the notices are served, then.
yes,
how come you?
Item 12.
Master Lordship.
I was required to file an additional affidavit. It is being filed today, my lord.
We have yet to receive any copy.
It is being filed, my lord. The department is coming back.
Okay, and in concept, Mr. Majumdar has submitted the additional affidavit pursuant to the direction given by this court on 7/6/2024. Additional affidavit. He is going to file additional affidavit today. Copy of the said additional affidavit is supplied to concept for the respondent in be respondent and list this matter after summer vacation. Or summer vacation, that's all.
Item 13 and 14.
In this matter, in item 13, Lordship, I have the instructions to appear for the respondents here in Lordship.
All the respondents?
Yes, Lordship. I would like to file an objection, Lordship, in this matter.
105 days.
Yes, Lordship. A short date may kindly be given, allowing me to file it.
There's a cross appeal, my lord. They have also filed appeal. We have also filed appeal, my lord.
They would
So
like to
in
file
any
it,
case, the
but-
matter has to be hard.
what's the problem? Let to know the data and this connected appeal along with the other appeal.
Lordship, actually, it's being readied and that objection is being readied and it will be filed, Lordship, within 2 days. Lordship, consider it once. and-
Note your objection, you are seriously opposing the application.
Lordship,
Note your- Mr. So-and-so put in appearance on behalf of all the respondents. So this is therefore complete. This IA is filed on behalf of the appellant with the claim unknown the delay of 105 days in filing the connected appeal. Full stop. And then counsel appearing for the respondent has vehemently opposed the application. However, taking into consideration the fact that a cross appeal against the impugned order has already been filed on behalf of the respondent, Hindustan Petroleum Corporation Limited. We deem it appropriate to condone the delay in filing the connected appeal. Hence, IA number so and so is allowed delay of how many days? 105 days. In filing the connected appeal is condoned. Registry is directed to has to register the connected appeal and list it for the hearing along with writ appeal number 40/2024. Connected appeal is 40/2024 for admission. After summer vacation.
in item 40, there is an interim order that may continue, Lordship.
We are not passing any order in this item number 14 that will remain in current.
Obliged, Lordship.
Item 15.
Maybe lordship. Lordship, the last occasion of the court is directed to the respondent authority
Well, you are supposed to file a counter
counter.
to the IA.
There appears to be a communication gap, my lord. I did not have the order. NJ Khatoni had appeared. There's a communication gap. Lordship will give me a week, my lord. Maybe till Friday I'll have it.
Standing counsel for the education elementary department needs some more time to file. Counter to the IA number so and so, time frame for example. Based on 18th of July
My lord.
Yes, master lordship.
or 17th of
17.
17th of July.
My lord.
Yes. Master lordship.
Item 16.
May be allowed. And this writ appeal filed by the state, there has been a delay. In fact, a review application was filed. After the dismissal of the review, my lord, we have filed within 1 month. The review application was dismissed on 7/9/2023. And on 4th of October 2023, we have filed the writ appeal. Anyhow, my lord, this one report directed that we should file an application for condonation of delay. We have filed that, my lord, and they have filed a reply also to that.
You are appearing for all the respondents?
I am appearing for 2/7/2016.
This 1, 3, 4, 5, 6, 7, 8, 9, 10.
Rest, I am attending, my lord.
What do you want to say?
My lord,
I have not filed any objection. I will not object.
Just one,
my lord,
Since the review was pending and there after dismissal of the review petition, they have filed.
it is not a composite appeal, my lord. It's an appeal against the single judge judgment. First of all, my lord, they have not explained any delay. What happened in judgment was passed on 26/22. On 5/7/22, we submitted a representation before the principal secretary, they implement the High Court. In response to that, our letter, your lordship kindly have a look at my affidavit at page 19.
Page 19.
19, my lord. Has your lordship got it?
Page 19.
In my affidavit, my lord.
Yeah.
Top corner, my lord, High Court urgent reminder. Lord, the letter was issued by the government. Here, your lordship will, may I read it, my lord? In inviting a reference to the subject cited above, I am directed to inform you that another application from Bobby Dekar and Kiroda Dekar, petitioner in WPC number so-and-so has been received in this department for taking necessary action as per High Court order dated so-and-so passed in the aforesaid case. In the light of Honorable High Court order dated by letter as referred above, this department has requested to intimate the step taken to file a writ appeal in the aforesaid case, if any. However, no response has been received from your end. Therefore, you are requested once again to intimate this department urgently about the step taken to file the writ appeal. The government took decision in July itself, my lord. They have not filed it. They filed appeal after 440 days.
But in the meantime, they decided to file a review petition.
My lord, after government decision, my lord, who has taken this is a appeal filed by the government, my lord.
Maybe the advocate concerned had advised them to file a review instead of filing a writ appeal.
No, my lord, review also delayed, was dismissed on delay, on the ground of delay, my lord.
How many days delay was there in filing the review?
Review, my lord, review was filed after 5 months, my lord, 5 or 6 months.
The review petition was pending, and suddenly.
No, my lord, I'm not disputing anything, my lord. What I am on, my lord. Look, if sufficient ground shown, my lord, I am not going to oppose it. But yeah, the conduct, my lord, when the government directed them to file appeal, my lord, government took decision to file appeal. Who took the decision thereafter to file review, my lord? That government took decision, my lord, in July itself, my lord, 22.
Yeah. Anyway.
Well, my only objection to that action, my lord, because of that, my lord, there is no sufficient ground shown in the condonation of delay to condone the delay.
Yes,
I just wanted to point out that the review order has not been challenged.
review order is not supposed to be checked. The original order is required to be. Review order, nothing, they,
Dismissed.
application for review has been dismissed.
But otherwise, there is a judgment, specific judgment on this point. If the review is dismissed, then appeal is to file against the original order. This judgment is there.
No, that I am not disputing it. my lord.
You are not disputing. Okay. Matter comes upon for consideration of the IA number 24 with the prayer to condone the delay of 440 days in filing the specific connected appeal. When it wanted for the applicant has submitted the review could not be filed against the impugned judgment. The appeal, writ appeal could not be filed within time against the impugned judgment since the department has filed a review petition before the last single judge. It is submitted that soon after disposal of the said review application, within 1 month, the connected appeal is filed. On the concept of hearing for the respondents agreement, we oppose the application and has argued that as a matter of fact, the applicants have not satisfactorily explained the delay of 440 days in filing the connected appeal. It is submitted by the counsel for the respondent number, private respondents.
Yeah.
Private respondents that as a matter of fact, the government has already decided to file the writ appeal against the impugned judgment dated 20th of June 2022 in the month of July 2022. However, despite the said decision, the appeal is filed, the connected appeal is filed against the impugned judgment after a delay of 440 days. It is contended that there is no explanation on the part of the respondents that when the government has decided to file an appeal itself in July 2022, where was the occasion for the appellants for the applicants to file a review petition before the learned single stop. And the council has therefore submitted that since the delay in filing the connected appeal has not been explained satisfactorily, the no case for condoning the delay is made. Stop. Having heard the learned one for the party and after going through the contents of the application and particularly taking into consideration the fact that the writ appeal is filed against the impugned judgment soon within 1 month of filing of disposal of the review application, we deem it appropriate to condone the 440 days in filing the connected appeal. Hence, the IN number so and so is allowed. Delay of 440 days in filing the connected appeal is condoned. Registry is directed to. It is already registered. Registered. Registry is directed to list the writ appeal number 398 of 2023 for admission after some.
Lots of would like to give a specific date, man, specific date.
Twenty-ninth of July.
Man. Apply.
Item 19.
Made with your lordship. Lordship, it is an appeal by the state lordship. Your lordship are pleased to admit identical appeal. Lordship, I am placing an order.
And concept of the appeal. Appellant has submitted that identical appeals against the impugned judgment has already been admitted by this court. Hence, admit issue of this returnable 4 weeks registered AD connect with appeal number 50 of the 2024.
Obliged.
Item 20.
May it please your lordship. Lordship, this petition is directed against the order dated 9/1/2023 by which the OA was allowed, lordship, directing for promotion to the post of mate, lordship. Now, so far as lordship, lordship, can you see that service rule which I have not annexed, lordship, permits only the PO from peon. It's only possible is daftari, lordship. Chain of line is lordship. Peon to is daftari, lordship, not mate. The second page, Lord. And lordship, the tribunal while allowing the writ petition, lordship, has allowed on a communication, lordship will find at page 40. That is only a welfare measure and that does not give any right, lordship. And only cherry picking of few lines, lordship, the OA was allowed, lordship.
Where is the office order dated 17/1/2014?
17/1/2014, Lordship. Page 118, Lordship. It deals with Chowkidar and Safai Wala, not peon, Lordship. And he is peon, Lordship. And Lordship, since 2013, there is only, all has been cadre, all cadre has been given to multitask MTS, Lordship, which is multitasking. Multitasking staff. There is no longer mates and all, Lordship. And the new rule, Lordship,
This promotion order dated 30th of December 2014.
2014, Lordship.
Mixture A10 to the
Lordship, page 43.
40,
30 December 2014, page 43.
43.
Lordship. The promotion itself says is Chowkidar and Safai Wala to mate. Page 43, Lord.
The list is not there.
Lordship,
List is there.
list is the next. All our Lordship, Safai Walas and Chowkidar's Lordship.
Not a single peon.
Not a single peon. And during that period, he was at, not at Silchar, he was at Tejpur. He came to a division only in 2016, Lordship. And if your Lordship goes through the 2013 rules, now mate has been a direct recruitment.
Here in the judgment, they referred that 70 employees, including peon, Chowkidar and Safai Wala.
No,
were
no,
promoted to the
no,
post of
Lordship,
mate.
that is not correct. No peon was, that is categorical stand, Lordship. Not a single peon has been promoted, Lordship.
Okay. Then the concept of petitioner that submitted that. While HQ 137 letter dated 30th of December 2014. 70 employees who were working as chowkidar and safai walas were promoted to the post of mate in fact, in bracket elect. But no employee working as peon was promoted to the post of mate elect. Stop. It is submitted that in such circumstances, the case of the respondent that similarly situated persons were granted promotion on the post of mate elect was incorrect. It submitted that the tribunal, without taking into consideration this fact, has illegally allowed the OA while impugned order dated 9/6/2023. It is further submitted that what you are referring to this,
Lordship, now the 2013 rule, Lordship, mate is now direct recruitment, Lordship.
it is not.
Direct recruited, Lordship. No promotion is there, Lordship. Second page, Lordship will find. Mate, then Lordship, at the third page. Column number 10, 80% direct, 20% by deputation.
Promotion rate, the promotion is to be made, mates. If this
2013 rule,
2013,
Lordship.
these are the 71, first you have referred to the 71.
Lordship, 71 rule, Lordship.
Yeah.
It says that from peon, you can go only to daftari, Lordship. The second page, schedule.
Second schedule.
Second page, schedule, Lordship.
Schedule, yeah.
At the top, daftari, Lordship. And Lordship say, Lordship will find promotion. Peons with 3 years service in the grade.
It's further submitted that as per the military engineering services in bracket non-industrial bracket close class 4 and class 4.
Class 3 and
Class
4.
3 and class 4 posts. Non industrial class 3 and class 4 bracket close recruitment rules 1975. A peon can only be promoted to the post of daftari on the condition that he has served 3 years of service as peon. Quick stop. And once it further submitted that as per the military engineering services industrial group C tradesmen male in bracket semi-skilled bracket close post recruitment rule 2013. The male is a post of direct recruitment. Is further submitted that all these aspects have not been taken into consideration by the tribunal while passing the impugned order. Issue notice of stay application also. In the meantime, the effect and operation of the impugned order dated 9/6/2023 passed by the CAT Guwahati shall remain stay.
Deeply obliged.
6 weeks. Registered date.
Item 21.
May I please, Your Lordship. Out of this present impugned order, Lordship, another writ appeal is pending before this honorable court, Lordship. Matter may be taken up.
Whether it appeal by whom?
Others, writ petitioner, there is a more writ petitioner.
What happened in that writ appeal?
This is pending before this honorable.
Pending,
Not
whether the notices have been issued or?
Yes, notices we issued, they're pending admission. Only one point, my lord, this
there's a IF in special leave by the wife of one of the repetitioner. The repetitioner had expired.
But IA is not here. It's that IA,
Rahina Begum, her husband expired after the repetition was disposed of and the period of limitation was over. Poor person, she has also joined in as an appellant and she has paid for special leave to appeal on behalf of the husband. That, my lord, since only that needs to be disposed of, my lord, either granted.
She's already,
She is a party. In
she's a
the,
party as appellant.
as an appellant, yes. She has been,
It can be disposed of.
yes, that can be disposed of, otherwise it will remain.
Then concept of the parties have submitted that against the impugned order. Some of the agreed persons have already filed. Date appeal number?
190/2024. In this writ appeal itself, she is a party. Oh,
The party. Date appeal number?
190/2024.
190/2024. And the same is pending consideration. In such circumstances, we deem it appropriate to list this. Date appeal along with date appeal number 190/2024. IA number so and so is put on behalf of the applicant with the prayer to grant leave to file writ appeal against the judgment passed by the Lalit Singh judge along with the other appellants. Full stop. It is the case of the applicant that after the decision of the writ appeal, her husband, who was one of the petitioner, died, and therefore she may be allowed to file appeal against the impugned order passed by the Lalit Singh judge along with other appellants. Having gone through the contents of the application, we deem it appropriate to grant leave to the applicant to challenge the impugned order along with the other appellants. In this appeal, the appeal number 2.
Item 22.
May I please, sir? This appeal is filed by the department against the order dated 15/6/2023, whereby the appeal of the
Question
department.
of law has already been framed.
Lordship, question of law was not framed, Lordship. Last time on 7th, I entered appearance, Lordships.
That has already been framed, sir.
It is there.
8/12/2020.
Lordship, but it was not served. There was no appearance from our side, Lordship.
The court has already framed the question of law.
Lordship, if your Lordship allows me 2 minutes. Lordship, the issue is regarding, I was getting a benefit under 20/2007, which is a Northeast exemption notification. I applied for a notification as a new unit. The original authority rejected my refund application stating you are a new unit, but because you have not satisfied one of the conditions, my new unit was verified. A physical verification was conducted by the original authority whether I qualify as a new unit or not. Department prefers an appeal against that rejection order of my refund before the Commissioner of Appeals, on the ground that the observation of the original authority that I qualify as a new unit as per 20/27 is incorrect.
Because this unit was operational before.
No, Lordship, that
what does their stand is?
Lordship, the stand, but Lordship, the problem where I am stuck today, Lordship, the question whether I am a new unit or not, it's a purely question of fact. Lordship, all the below authorities, then they preferred an appeal before the tribunal. The tribunal rejects their appeal. They come before your Lordships. Lordships, whether this court under 35G can examine when the lower 3 authorities have determined this is the documents that I am eligible as a new unit.
But sir, if that finding is altogether perverse and taking into consideration the fact that your, maybe rightly or wrongly, that your unit was in existence prior to passing of the Supreme Court judgment,
Lordships.
and the same unit has applied for some concessions or what?
Lordship, the same unit in this case, it cannot be Lordship because it was entirely dismantled and shifted to Gujarat. All those documents the tribunal and the lower authorities consider. The letters of the Directorate of Factories, the Directorate of Fire License, the Directorate of the Northeast Department, everything has been considered by all the lower authorities. Lordship, may kindly take the tribunal judgments. And Lordship, last time Lordship when I appeared virtually, I requested my Lordship leave to submit this paper book which was submitted before the tribunal.
The paper book by you or the?
By us.
By
us.
Submit this paper book. File along with this appeal. We consider it. File along with this appeal.
Lordship, appeal, it is.
You place it on record.
Lordship.
Is whatever.
I'll place it down, Lordship.
So, this court filed order dated 8/12/2023 has already framed the substantial question of law. However, learned counsel appearing for the respondent has submitted that those question of law has been framed without even issuance of notice to the respondents. Full stop. It is used by the learned counsel for the appellant that whether the respondent unit is a new industry or old is a question of fact, and the three authorities have decided against the revenue while recording a specific finding of fact that the respondent unit is a new industry. It's stop. Learned counsel for the respondent takes some time to place on record the documents and the submissions filed on behalf of the respondent before the tribunal. Time period for is granted. The time period for is granted. The requisites be done within a period of 2 weeks. Is this matter for admission on 26th of July.
Grateful.
Item 23.
Yes.
May it please your Lordship. Lordship, by the last order, your Lordship had directed the state government to bring on record the reports.
From the.
The reports from the ICAR Guwahati and ICAR Cochin.
Yes, what happened?
So that has been filed, Lordship.
It has been filed by.
Lordship, at page 216, if your Lordship kindly sees, this is the report from ICAR Guwahati.
What about some Calcutta also?
Cochin, my lord. Guwahati and Cochin were there. So as per the Guwahati reports, traces have been found in 3 of the fishes out of the 12 samples sent.
Fine.
And below it is written that the traces were below the detection level of mg per kg or ppm. Now, my lord, the reason why this has been written in the report, means what does the authority mean by this? It is not very clear.
Yeah, we don't understand. What do you mean by the traces below the detection?
Below the detection level of mg per kg or ppm. My lord, the FSSAI rules provide the maximum limit in the terms of mg per kg, that in freshwater fish, 4 mg per kg of formaldehyde, that is the maximum limit permissible. But here it is simply written that traces below the detection level of mg per kg or ppm. So what is the reason behind that? It is not very clear.
This what mean the reason. They have not detected traces below the detection, so and so. There were traces, there are traces,
My lord.
but that is below the permissible limit.
Below the detection level. Below the detection level. Earlier, my lord, also number of reports have been filed before this honorable court.
Never means that. Though they should have mentioned here that permissible limit or something else.
My lord, we don't know. And secondly, my lord, the Cochin, at page 218,
218.
lordship. It is a letter from the Cochin office. It reads,
Testing of permission so and so.
with reference to the subject cited above, I am to inform you that the 3 numbers of samples which were sent to CIFT Cochin for testing the incidence of formaldehyde were totally spoiled and not fit for analysis.
You have to send some fresh for that.
Lordship, we have explained that in the affidavit, Lordship, that due to some eventuality, that consignment got damaged because of the hot weather, but
But now you have to send it again for that.
I'll instruct the agency to.
If these samples were spoiled, you have to send it again.
Otherwise, Lordship, the Guwahati lab sample, Lordship, that has been.
Okay, once you have decided to send it to the Guwahati and Kochi, you should get the report from the Kochi also. What's harm in that?
I'll follow up.
It's a matter of public interest. These fishes are to be consumed by the people at large. They have a genuine concern for that.
Lordship, I'll follow up and ask them to.
Okay. The concept of the respondent state is filed in affidavit along with the report received from the Northeast, from the Fisheries Research Institute, Northeast Region at Guwahati and Central Institute of Fishery Technology, Cochin, Kerala. Full stop. As per the report received from the Fisheries Research Institute, Northeast Region at Guwahati, the dihyde was not found crossing the permissible limit in the samples sent. However, the Central Institute of Fishery Technology, Cochin, Kerala, failed to submit its report since the samples sent to it were spoiled and not fit for analysis. Full stop. And counsel appearing for the respondent state has submitted that fresh samples will be forwarded to the Central Institute of Fisheries Technology, Kochi, very soon. And the report from the said institute will be submitted before this court as soon as it is received. It's possible. 6 weeks time is granted to the court, to the state to do the needful just after 6 weeks.
Deputized.
Item 24.
Lordship, we have received para-wise comments, Lordship. We have to find our reply, Lordship. 3 weeks time may be granted, Lordship.
Sir, Chakraborty, it's 3 weeks time to file counter affidavit.
Interim order may be continued. Interim order may be continued. Interim order may be continued.
Interim order, if any, to continue till next.
Item 26.
May it please the lordships. My lord, in this matter, although we had assailed on the count that the honorable single judge proceeded on the premise that we had not sent notice to the government before meetings and all, because government having a chair therein should have a nominee therein under section 43(8) of the act. Now, so far so good, the council also did not know about it, but when we could lay our hands on such documents, communications, we filed the appeal, preferred the appeal. Now, my friend on the other side is very rightly objective to so that you should not bring it this up in appeal because it was never before the honorable single judge. Therefore, conjointly we pray that Lordship may be pleased to allow us to withdraw and prefer review application on these two documents and no more.
Lordship, two new documents were placed, Your Lordship, which we have filed objection. If you
That's all.
wants to prefer for review, Your Lordship, we have no objection.
Let me consider the appeal. Without arguing on merits and submitted motion, he wants to withdraw this appeal with liberty to file a review petition before the London single judge. When counsel appearing for the respondent has no objection, liberty is granted. Circumstances, the writ appeal is dismissed with liberty to the appellants to file review application before.
Would my lord be pleased to indicate that scope, the documents which are
In accordance with.
Lordship.
Right.
Item 27.
May please, sir. There is an appeal by ONGC. Today it is fixed for consideration of the interim.
Consideration of the interim order.
The notice was issued on 14/6. And the writ petitioner has already entered appearance. The learned single judge.
Yes.
Yeah, the appeal is one.
The temporary disability certificate is is in currency up to 2025. No, opinion for you to discard that temporary disability certificate.
Because the rules do not provide. In fact, that is the aspect which has been overlooked by the learned single judge. Firstly, my lord, first issue is the advertisement will clearly disclose that the post in question itself is a regular vacancy, a permanent vacancy. Now, the learned single judge has directed temporary appointment against a regular vacancy, and that to a person who is not eligible under the provisions of the act and the rules.
No, temporary, no, learned single judge is not directed, temporary appointment.
If your lordship kindly allows me to place that paragraph.
Yeah. This, para number 12.
Para 12. After examining the balance of convenience and in the interest of justice, the ONGC authorities are directed to issue appointment order to the petitioner to the post of junior technician diesel under the disability category up to 25/2/25. That is, it should have been
Date 12.
corrected. That is the date of validity of the temporary disability certificate of the petitioner. This court makes it clear that this shall not be a precedent in future for other cases. It is further made clear that after the expiry of the validity period of the temporary disability certificate of the petitioner, he shall undergo the required medical test before the competent board, and if it is found that his degree of disability has gone down below.
Respondent?
I'm for respondent one, my lord, for a petition.
Read petition. In fact, my lord,
Have you obtained that permanent disability certificate by now?
No,
Why?
because there is a medical authority, we approached this, we approached also that they have told that there's no provision. In this regard, affidavit is also filed by learners.
There's no provision?
No provision for giving permanent certificate before 25 to, then thereafter, this is affidavit filed by, I went there. It is truly speaking, I went there because I am interested for service. I'm ready to go for today also. But as chairman, disability board has declined to entertain me because
Where is that document?
that is affidavit is my lord. Affidavit is there, affidavit lordship may peruse.
Where is that?
Yes, lordship may peruse. 114. 114. Lordship may 114 last paragraph, lordship. Lordship got it. 114 page. Lordship. Page 114, last paragraph. In view of the above, earlier this variation, it is respectfully submitted that the certificate in respect of Sri Ankit Chege, that is me, has been recommended by the district disability board chief secretary for 3 years, 5 months, and the same is valid up to 25/10/2025. After expiry of the validity period, petitioner Sri Ankit Chege will have to apply for online as per guideline, and thereafter he will have to appear before the board for proper assessment, and board will decide for issuance of permanent certificate accordingly. This is the stand of my learned friend
Who is appealing for?
for. I'm ready to go even today also.
What is this? Yeah,
Right.
Issuing any permanent disability certificate? Which is that rule which prohibits you?
As per my affidavit.
Yeah, like, yeah. Come here.
Lordship 114, Lordship, the second paragraph.
Lordship, it is pertinent to mention herein that as per clause 4, 3, 1 and 2 of the notification dated 30/12/2009 issued by the Ministry of Social Justice and Empowerment, it is clearly stated that a permanent disability certificate can only be issued in cases where there are no chances of variation over time in the degree of disability, and in case where there is any chance of variation over time in the degree of disability, the period of validity in the certificate shall have to be indicated. Lordship, since this pertains to Lordship hearing impairment.
Do you have the copy of this notification?
Yes, Lordship. Lordship, page 118, Lordship. 4(3).
Of December.
Yes, Lordship.
What's the fault of the applicant here?
But,
If they are not issuing him a permanent disability certificate, he approached them
but
and they have issued a permanent disability certificate up to a certain date with the hope that there may be some variation or may not be some variation. What's the fault of him? He approached them for that.
that is what the authorities are not at fault, madam. This is what the rules, that those rules have not been placed, madam. If your lordship will kindly allow me to place
The
this.
applicant is at fault.
That is because the authorities have gone by what is provided in the rules. And the rules provide for issuing such, if your lordship will just allow me to place the relevant provisions.
This, you can't,
May I just place,
put a applicant in such a position that where the authorities are not issuing permanent disability certificate and you are saying since you are not having permanent disability certificate, will not grant you appointment.
because madam, with greatest respect, madam, that is what the law provides for. If your lordship will just allow me to place the relevant provisions, madam. First, madam, may I just draw your lordship's attention to some of the relevant clauses in the advertisement. If your lordship will first take up the advertisement,
Yes,
starts at page 56.
yes.
If your lordship takes up page 56,
Yeah.
the fourth paragraph itself will clearly reveal that all these posts are regular posts. Oil and Natural Gas Corporation Limited invites online applications from young and energetic candidates for the following regular posts for respective ONGC work centers, etc. We are concerned with, if your lordship will kindly turn to page 61, we are concerned with A8. It's towards the top. Your lordship will find A8 ONGC work centers in Assam. And we are right at the bottom of that chart, A8, that is towards the top of the page, just above the chart, your lordship will find the heading ONGC work centers in Assam. At page 50,
58,
page 61.
61. '61.
Yes. At the top, there is a chart. Just below the chart, your lordship will find the heading A8 ONGC work centers in Assam.
Yeah.
And at the bottom of that page, we are concerned with this particular post at serial number 15, junior technician diesel. And your lordship will find there is a column for identified suitable for benchmark disabilities.
Yeah.
And we are concerned with category B.
Yeah.
Now, benchmark disabilities is, I'll come to that. This is defined in the Act. I'll come to that a little later. First, let me place the relevant clauses in the. Now, your lordship will kindly turn to page 66.
Yes.
Towards the right-hand side, your lordship will find a Roman clause 18. For persons with benchmark disabilities,
Yes.
certificate of disability should be issued by the notified medical authority in the format prescribed in the Rights of Persons with Disability Rules 2017. Your lordship will kindly note this one.
Yes.
Now your lordship will kindly turn the page to page 67.
Yes.
Again, towards the top right-hand side, your lordship will find there's a chart and there's a provision saying that for PWBD candidates, the benchmark disability should have been acquired on or before the last date of online application. And the end date of online application is also provided for. It is 28/5/22.
Fine.
Now, your lordship will kindly turn to the last page of the advertisement, page 69.
Yes.
On the right-hand side again, your lordship will, towards the middle, your lordship will find serial number Q, note. In that, there are two clauses which are important.
Yes.
That is, first is 2. Appointment of selected candidates will be subject to their passing the company's medical examination as per standards laid down under the ONGC's Medical Examination Employees Rules 96. Details of such rules are available, etc. And then 6, The eligibility of the candidate will be finally cleared after verification of documents. Mere submission of online application form or issue of admit card or call letter for further selection process doesn't establish the eligibility of the candidate. Now, based on this, what the certificate he submitted was at page 54. At page 54, your lordship will find A, he is a case of hearing impairment. B, the diagnosis is, his case is hearing impairment. Then C, he has 55% temporary disability in relation to his ears as per so-and-so. The certificate towards the bottom, the certificate recommended for 3 years, 5 months, and therefore this certificate shall be valid till 25/10/2025. Now, this is the certificate that he submitted. Now, we had our own medical board. We examined his documents. He had otherwise cleared the exam. We called for his documents. We examined this. Our own doctor also examined him. He also gave a report that it is a temporary impairment. Now, what the Act and the rules provide is, if your lordship will kindly have the Disabilities Act of 2016. The advertisement itself clearly said that persons with benchmark disabilities will be entitled for reservation. That is defined. Person with benchmark disability is defined at 2R, section 2R of the Act.
Persons with benchmark disability.
Mild. Person with benchmark disability means a person with not less than 40% of a specified disability. Your lordship will kindly note these words, because specified disability is again defined separately. Specified disability, where specified disability has not been defined in measurable terms, and includes a person with disability where specified disability has been defined in measurable terms as certified by the certifying authority. Now, your lordship will kindly come to ZC, subsection ZC. That defines benchmark disability. Specified disability. Specified disability means the disabilities as specified in the schedule. Now, if your lordship kindly turns to the schedule. Page. Yes. Yeah. This provides for the specified disabilities, and at capital C, your lordship will find hearing impairment.
Yeah.
Deaf means persons having 70 decibels hearing loss in speech frequencies in both ears. Hard of hearing means persons having 60 decibels to 70 decibels hearing loss in speech frequencies and in both ears. So it is defined in measurable terms. So therefore, we have to go by this. Your lordship will find that the certificate, in spite of the fact that this is in measurable terms, the certificate does not mention the extent of the impairment in decibels. Now, how the certificate is to be issued is provided in the rules. If your lordship will kindly turn to the 2000, it's part of the rules book.
Yeah.
If your lordship will kindly have the 2017 rules framed under the Act. If we are holding the same book, it should be at page 51.
That is the form.
No, this is where the rules start. I'm just taking your lordships to the relevant provisions of the rules. If your lordship will kindly turn to rule 17 first.
17.
17. So the rules very clearly provide as to the entire process of applying for and issuance of the certificate. and what benefit will be given. Now, first, Rule 17. Any person with specified disability may apply in Form 4 for a certificate of disability and submit the application to the medical authority. We are not really concerned. Once this application is submitted, what the authorities are required to do is at Rule 18. Issue of certificate of disability. On receipt of an application under Rule 17, the medical authority or any other notified competent authority shall verify the information as provided by the applicant and shall assess the disability in terms of the relevant guidelines issued by the central government. And after satisfying himself that the applicant is a person with disability, issue a certificate of disability in his favor in Form 5, 6, and 7, as the case may be. So it can be either in Form 5, 6, or 7, whichever is applicable. And what will be the benefits that will accrue is at Rule 19. A person to whom the certificate issued under Rule 18 shall be entitled to apply for facilities, concessions, and benefits admissible for persons with disabilities under the schemes of the government and of non-governmental organizations funded by the government. Now, if your lordship will, this includes reservation in post. Now, if your lordship comes to the forms, it's the Rule 18 says that the certificate has to be issued either in Form 5 or 6 or 7. In our case, the applicable form will be Form 7, because Form 5 is for amputation and complete permanent paralysis of limbs. Form 7 is in case of multiple disabilities. So in the present case, the form ought to have been issued. The certificate ought to have been issued in terms of Form 7. And if your lordship sees has a look at the form, in the right-hand column itself, it makes it very clear that the nature of the disability has to be permanent in nature. If your lordship has a look at the chart.
Form number 7.
Form number 7. First, it provides for the photograph, etc. Then there's a chart provided. And in the chart, extreme right-hand column, your lordship will find permanent physical impairment. And insofar as impairment is...
Just a recent passport photo showing face only. Definitely carefully examine date of birth, registration number. The next bit, permanent physical impairment, mental disability in percentage.
Yes. And if it is in measurable terms, it will come under that specified disability. And here, in case of hearing impairment, it is a measurable, it is provided in measurable terms that it has to be either 70 decibels or 60 to 70 decibels. So therefore, my lord, if your lord, and
just
In fact, my lord,
Now you are raising all these, whatever the technical or whatever the objections regarding the rules, you have not mentioned in your counter to the writ petition. You have simply said, since he has submitted a temporary certificate, therefore we are not.
because that is what we are bound, our lordship is aware, my lord, we are, will be bound.
Sir,
And there is,
Sir, what's the fault of this person? He applied to the medical authority
if he,
for issuance of certificate. What is the format? What is the requirement? If he has not mentioned, how is it a fault?
but your lordship will, in fact, there is a further interesting aspect which has been overlooked by the, if your lordship will allow me to place the affidavit filed by the issuing authority, the authority who issued the certificate, your lordship will find that at page 112. Very interesting thing, my lord. This opens up another, he is, perhaps he is not eligible at all. If your lordship will kindly, it starts at page 112.
Yeah.
Your lordship may kindly turn to page 113, para 3.
Yeah.
That the answering deponent begs to state that as per record available in the office of the undersigned, the disability certificate in respect of Sri Ankush Saikia, that is the writ petitioner, which was issued by certificate number so-and-so, dated 25/5/22, against the case of hearing impairment with 55% temporary disability, as per notification of Ministry of Social Justice and Empowerment, Government of India. And this notification, if your lordship will kindly turn to page 115, they refer to this notification. In fact, they have annexed it. Copy of the notification dated so-and-so of social justice and so-and-so is annexed as annexure 1. And this annexure 1 is at page 116. And your lordship will find that this is a notification under the earlier act, repealed act. Page 116, your lordship will find. So the certificate is not even issued under the act which is in force. So
the question comes to probably how this poor person.
I absolutely appreciate. We are as an organization, my lord.
He went for this certificate. Now under which rules, which format?
But the problem that would happen is, I'll just to give a hypothetical example. Tomorrow, what might, because the whole idea and purpose behind the act is to provide for reservation for persons with permanent disabilities. Now tomorrow, a hypothetical situation. A person meets with an accident, fractures his limbs, and he comes up with a temporary certificate that I am disabled.
Certainly, that may be it.
So this might open up a floodgate for.
No.
And in fact, a similar situation, that is why we filed an additional affidavit today. Similar situation had apparently arisen in case of Indian Oil Corporation also. And they sought a clarification from the Union Ministry, the Nodal Ministry. And the clarification that has been given, if your lordship will kindly have the additional affidavit that has been filed today.
By whom?
By ONGC, we are filing. And your lordship will find the clarification given by the Ministry of Social Justice and Empowerment, Government of India, at page 153.
The guideline equivalent.
Council, what you are relying on is repealing the provisions of the act?
Lordship, in the 2017 rules, Lordship, there is a provision under Rule 18, Lordship.
Which is that rule? Your case is that you have issued him a certificate relying on these rules which are already repealed.
But Lordship, it is still in.
What is this? Is this a joke? A person applying for you for certificate and you are issuing the certificates in the old format or whatever may the rules which are not at all applicable.
But Lordship, under 18.
You are playing with the future of the candidates.
But Lordship, as per Lordship 2017 rules also, Lordship, 18 Lordship, 3 Lordship.
Sir, what do you mean? Your affidavit says that we have issued this certificate taking into consideration these rules.
Yes, Lordship.
Whereas 1995 rule has already been, this act has been already repealed with the enactment of this 2016.
16 Lordship.
What you are doing? Definitely. How a person came to know about this? He simply applied for a certificate and you have issued a certificate in the old certificate, old rules which are not at all in operation.
Lordship, in that Lordship, can he appear before the medical board, Lordship, if Lordship direct?
What do you mean by can he appear? Whether you are following this act of 2016 or 1995?
Lordship 2016, Lordship.
Where is that? Your affidavit says that we have issued a certificate in the old rule.
Yes, Lordship, in the affidavit, Lordship, it is.
See, what business is going on here?
As I was indicating to your lordship, identical situation arose in IOC, and that clarification is at page 150.
Ultimately, how he is at fault?
I absolutely, we are in a absolute catch-22 situation. As an organization, we are bound by the act and the rules. We would, that is why we provided for the reservation.
You just see the plight of a poor man who applies for it and they are issuing a certificate under the old rules. How he came to know and what is his authority
it's
to
a very
ask them, no, issue me a certificate in
sad
this
state of
format
affairs.
or everything.
And in fact, my lord, with greatest respect, the petitioner was all along aware of this position. If your lordship sees the email, he was, your lordship will kindly turn to page 111. It is not that he was not aware. Page 111 is an email he wrote to us
Yes.
as late as on 13/6/2023. And your lordship will kindly, it is at page 111. And your lordship will kindly see the contents of he was fully conscious of the fact that firstly, he will have to have a permanent disability certificate in proper format. And that is why he was asking for further time, which we allowed.
You are now on up to 29th, you gave him time.
We gave him as much leverage, as much leeway as possible. But in spite of that, when he couldn't come, he was fully conscious about the legal position.
But though he applied with, he approached the authority, but the authority has declined to give him a certificate. What's fault? What is fault, sir?
Although the advertisement says that documents have to be as on the date of application, we gave him that extra liberty that you go and get the certificate.
That's right.
We tried to be as fair as possible, man.
That was reasonable.
As fair as possible. But we are also bound by our own advertisement. We are bound by the law of the land. So, and even in the last email, you also will find that we still gave him a further chance. That we are giving you a further period of some up to page 88, you'll also will find the last email given by us. We gave him further time. The best possible.
Raised all these points before the learned single judge. You have not raised all these points before the learned single judge. You simply said it's a temporary certificate, permanent certificate is not there. Therefore, we are not going to.
Perhaps things were not. Our difficulty is the very reason we provided for the reservation is so that the eligible persons get the benefit. The only difficulty is that if he proves to be ineligible, then we will be in a real suit. My respectful submission, my lord, there are perhaps issues which your lordships might like to examine. Unless it is said they will,
Heard and the concept of the parties. On the interim prayer made on behalf of the appellants. Respondent number one as approach. This court by filing of writ petition number 3832 of 2023 being agreed with the action of the respondents, but we being agreed with the action of the appellants of not providing him appointment on the post of junior technician junior technician in bracket diesel on the ground that he failed to obtain a permanent disability certificate from the competent authority. The learned single judge has disposed of the writ petition with the direction to the appellants to issue appointment order to the petitioner to the post of junior technician diesel under the temporary disability certificate up to the validity of the said temporary disability certificate. To the respondent number one, to the in place of petition. Then it concept of the appellant has submitted that the temporary disability certificate issued in favor of the respondent, private respondent, is no certificate in the eye of the law because the authority who have issued the said certificate in its affidavit filed in the writ petition, in its counter affidavit filed in the writ petition, has stated that the said certificate is issued as per the persons and disabilities in bracket equal opportunities, protection of right and full participation. Bracket close rules 1996. Whereas those rules has already been repealed with the enactment of the Right of Persons with Disabilities Act 2016 and the Right of Persons with Disabilities Rules 2017. Is further submitted that the said temporary disability certificate is also not issued in the prescribed format, prescribing the percentage of the disability as required under the Act as well as the rules. Stop. During the course of hearing, it is noticed that though the private respondent has approached the respondent number 5 with a prayer for issuing a permanent disability certificate. But the respondent authority, but the respondent number 5 has issued a certificate of temporary disability in favor of the private respondent, while taking into consideration the provisions of the repealed rules. Stop. We find that though the private respondent is not at fault, but the appellants can also be not, they can also not be held responsible for the omission on the part of the authority who is competent to issue the certificate, permanent disability certificate. Be that as it may, deem it appropriate to direct the private respondent to appear before the competent authority for the purpose of getting a permanent disability certificate within a period of 2 weeks from today. The authority concerned shall examine the respondent and the private respondent, and then shall issue a certificate in accordance with law after complying with the provisions of the Right of Persons with the Disabilities Act 2016 and the Right of Persons with the Disabilities Rules 2017 as amended from time to time within a period of 2 weeks thereafter. Stop. This writ appeal on 29th of July 2024. In the meantime, effect and operation of the impugned order dated
23/4/24.
23/4/2024. Also corrected by the order dated 1/5/2024 shall remain stayed till next day.
Deeply.
Item 28.
This matter is relating to disciplinary proceedings of the petitioner lordship. Notice was issued on the last occasion, reply has not yet been filed.
We need some time, madam, to file the reply, madam. At least, my 4 weeks time may be granted, madam.
And also the for the UR application.
No, 1, 2, 4, 5, and 6.
1, 2, 4, 5, and 6. Please some more time to reply to this petition. Counter to the petition titled for example list after
Item 29.
Lordship, here I pray for 3 weeks time to file reply, Lordship.
Once for the respondent is for and granted 3 weeks time to file counter to the
Lordship, there is an interim. Interim shall continue, Lordship.
interim order if any to continue till next date.
Obliged.
Obliged.
Item number 30, 31, and 40.
Please, your lordship, my lord. Am I audible, my lord?
Have you filed the counter?
My lord, we are seeking some time, my lord, to file the counter. In fact, my lord,
File the counter, the act is under challenge.
My lord, that
Validity
is
of
true.
the act is under challenge.
Lordship will kindly appreciate one aspect of the matter with all humility. My lord, this ordinance has been passed. It will be placed immediately when the assembly is sitting, my lord.
However, it may be, they have challenged the validity of this ordinance, raising certain questions, you have to file it.
My lord, my lord, my lord.
I am appearing for the, in
Yes,
item
in one of the
31, my lord.
In one of the written petition, you are
Yeah,
appearing.
sorry, my lord, today I am in virtual. I am out of station.
Mr. Das,
Yes,
at least the reply to the state government is required to be filed. Sir.
no, that's true. That's true, my lord. Your lordship just recollect. When your lordship was hearing this matter in the month of April, then your lordship has indicated that at least there should be some alternate legislation.
Yes, yes, yes.
Now
yes.
now the problem is that we are in limbo. That's the whole problem, my lord. Neither it can be registered, neither any proceeding could be filed before any court of law. That's the whole problem, my lord. Your lordship was in a view that some alternate legislation in the meantime they will come up. And my lord will kindly see 3 factors. They said number 1 is a Pre-Independence Act. There are so many acts. Your lordship has seen there are Pre-Independence Act.
Can't be the only basis, sir.
No, second is they said it is not compulsory registration. And the act says there is a compulsory registration. They amended the act. And number 3, child marriage. They can take care of the child marriage is concerned. But 1 and 2, the cabinet which they have taken a decision in pursuance to the ordinance has been issued, my lord. I think these are all immaterial, my lord. My lord, a large chance would be given to them, my lord, to file the affidavit.
Yeah. Let's file the.
Otherwise, your lordship will hear on the interim application, my lord.
Notices have been issued in
Yes.
petition number 2596/2024 and 2163/2024. On 20th of May 2024 and 24/4/2024 respectively. But till date, state has not filed the response to the challenge made by the petitioners. To the ordinance in question. Stop. Then it consider appearing for the respondent state raised for and granted last opportunity to file response on behalf of the state. How much time would you like to have?
Any short date may be given, my lord.
Short, how much short date?
Lordship will kindly grant me 4 weeks time with all humility, my lord.
Well, if it is not inconvenient, well, if it is not inconvenient to your lordship, can it be fixed on somewhere 16, 17 of July?
My lord,
On 1st of August.
my lord, I will be so deeply obliged, my lord. I will be so deeply
Of
obliged.
August.
If they doesn't file, my lord, then your lordship will kindly hear the interim.
We will see to it. So that's
Deeply obliged.
I'm obliged, my lord.
Obliged.
Item 33.
It speaks for interim compensation. The last order, your lordship will condition. My lord, I'm giving three judgments, my lord, where the compensation has been, my lord.
My lord, some deliberation in the highest level is going on to take a decision regarding my lord, making payment, because we don't have a scheme to make payment in the custodial debt.
Then we'll have to pass an order.
That lordship, this last opportunity must be granted, lordship, as a last chance, lordship.
My lord, interim compensation, my lord. My lord, your lordship
If we
will see-
fail to, my lord, file affidavit in a level, then lordship,
My lord, I'll place three judgments, my lord, the Sarla Verma case has to be followed.
Just want that some relief be granted to till this disposal of this. The only thing is that we pass any order, certainly they are going to challenge it again. You will face the same difficulty. We grant them time. At least to give them as an interim relief to some amount. We are insisting on that. Otherwise, there is no problem. We can very well pass an order, but ultimately by passing that order, you will get it or not. That's the whole question.
My lord, three judgments, my lord. I'll place it, my lord, next time, my lord, your lordship will look in.
We are aware of that. So that's why only we have made this.
Yes.
On 8/5/2024. This court has observed that the custodial death of the husband of the petitioner took place on 25/4/2020. And therefore, the explanation is required from the state government that why the interim compensation is not granted to the petitioner during the pendency of this writ petition. And the council appearing for the state has submitted that the matter regarding grant of interim compensation as well as the full and final compensation is under consideration with the state government. And therefore, some time, more time may be granted. Which stop. In view of the prayer made by the learned council of the plan, deem it appropriate to let this matter on 24th of July 2024. With an expectation that the state government shall come with a positive proposal for granting compensation to the petitioner full and final full compensation to the petitioner, and if not full compensation, at least interim compensation, at least a proposal for interim compensation is required to be placed before this court. Next time we'll pass an order.
my lord, I am deeply honored.
That we have granted
My-
enough opportunity.
My learned friend can take guidance from the Supreme Court judgment, how it is granted. I'll provide him.
For hearing, item 34 and 35.
My senior is left in court number 5, my lord, for the time being, my lord. Just he was
We
there,
don't have any other case.
he was here, my lord, but just one matter has come up.
25th of July.
Item 26.
Here I am praying for some little accommodation for today, madam.
Why?
We are not prepared actually, madam.
Yeah, file to the so one.
May I pray that madam is taken up after the vacation, madam?
Yeah.
Oblige.
Lord, may I pray for a date, my lord?
State of your affairs.
Oblige.
Oblige.
Just